Now coming to the second last point in my discussion is the important case laws. We are generally unaware of the development in the field of construction law and construction arbitration. There are a few very landmark judgments which, if we quote in our pleading in defense, then they can turn the entire discussion in our favor. The case in point, the first one is Ramnath International versus Union of India, decided by Honorable Supreme Court of India on 11 December 2006. It is a watershed landmark judgment only on condition 11 of 2249. It is a MES case and Supreme Court has gone into the details of condition 11. When the extension of time has to be granted, when not has to be granted, and in this particular case Ramnath International, Supreme Court has said if the extension of time is granted, then claim for prolongation and delay by contractor cannot be allowed. If you have granted the extension, then contractor cannot claim for the prolongation or the delay claim in their statement of claim. This is a very important judgment. The same judgment says that the arbitrator is nothing but the creature of the contract. He is the natural outcome of the contract. So the arbitrator has to abide all the contractual conditions and he cannot venture outside the scope defined by the contract agreement decided and agreed by both the parties. So this judgment, Ramnath International versus Union of India, is a very important judgment. Second is ONGC versus saw pipes. This is upon liquidated damages, section 673 and 74 of Indian Contract Act, and it says that if liquidated damages have been mutually agreed by both the parties, then there is no importance to prove the losses in an elaborate manner in order to levy the damages, levy the liquidated damages. This is again a very important judgment. Third is State of West Bengal versus Afcons Infrastructure Limited. This was decided by Honorable High Court of Calcutta on 7 July 2010. This is very important in view of the contemporaneous record and the evidence during the currency of the execution of work. It says that if there is no contemporaneous record against any claim put forward by the contractor, then he cannot ask for the damages or the compensation against such claim. If there is no record, then such claim becomes void. We have to push such judgments and such arguments in front of arbitral tribunal that there is no such contemporaneous record and this claim is an afterthought. Such claim was never put forward by the contractor during the execution or the currency of the work, and it is only when he is approaching the arbitration tribunal then he is coming forward with such a long list of claims. So if there is no contemporaneous record, such claims are not admissible. This is a very important judgment. Next is Mecon Limited versus Pioneer Fabricators, decided by Honorable Delhi High Court in 2007. It is upon the defaulting parties and it says that the party, if it is responsible for the delay, it cannot avail the benefits of the delay. A party, if it does the delay, it cannot later on come and say that they should be given the claims or the damages for the prolongation. This is important with respect to the concurrent delays. Concurrent means when the delay is happening from both the parties. Then if both the parties are at fault, let's say there is a design issue with respect to the department, as well as there is no mobilization of TNP and manpower from the contractor side, both the parties are at fault, then in such a situation the contractor cannot ask for any kind of benefits because he is also at fault and he is responsible for the delay. The next is PSA Sikal Terminals Private Limited versus Board of Trustee Chidambaram Port, decided by Honorable Supreme Court of India on 28 July 2021. It is again a watershed judgment, very important judgment. It says that if the tribunal has given the award on the basis of either no evidence or it has ignored a vital evidence, then such an award is perverse. It is patently illegal and it is liable to be set aside. It is again important with respect to the contemporaneous records. If it is non-existing, then this judgment becomes very, very important, and it is also important with respect to the any false and fabricated evidence such as false wages receipt or any correspondence or letter inserted by the contractor during the arbitration proceedings. So they are no evidence, they are not the authentic evidence. If they are no evidence, then such award becomes perverse if it is based upon such evidence. At the same time, if there is a good amount of vital evidence put forward by either of the party, let's say by Union of India, and the tribunal has disregarded that evidence and given the award, then also that award is liable to be set aside and becomes perverse and patently illegal.